Sorry about this dishonesty. Welcome all to Juris North. As you may all know, we are a discussion group. We have 8 chairs in 9 different locations. We right now have 9 universities. So I'm going to briefly introduce our chairs today. We have Professor Dr. Michael Gordon from University of Liverpool. Hi, Mike. We have Dr. Christopher Fear from University of Hull, Politics and International Relations. Hi, Chris. We have Josh, I can see his name, I cannot see his face. Josh Howitt, Legal Theory, this case, from University of Newcastle. Ah, there you are, Josh. Nice to see you. And here, Jorge, you all know my face from Manchester Metropolitan and Manchester University. I represent both universities here in Manchester. Very briefly, before I introduce our presenter today, and we are very lucky to have him here, very briefly, again, for the ones who are new to what we do, we are quite a weird group. We cut across universities, and that's the idea. We have 8 chairs, different places, different universities, and we try to offer an open platform for discussions. We will have one expert today, Professor Bruce Ackerman from New Haven, University of Yale, and the rest of we are simply mortals. We are here to know more. We don't have professors, we don't have students, we don't have lawyers or political scientists. We have people willing to learn from each other. So thank you, Professor, to play this game with us. And very briefly for the admin side, we will have Professor Ackerman talking to us for about 40 minutes. After that, I will let you all know we'll stop the recording because we have people from different jurisdictions. So I'm going to stop the recording. I'm going to only be recording the first part of the session. After that, we will open to questions and answers. We are conscious we may have introvert and extrovert people or people from different cultures. So if you want to ask a question, but you don't feel to like speaking up, at the bottom of the menu, you should have a chat box, write your question, and I'm more than happy to talk on your behalf, to speak on your behalf, and I'm going to read the question. However, if you do want to ask Professor Ackerman a question, simply raise your hand because we will have quite a few people today. This is our busiest session so far in 6 years. So if you do have a question, please, and you want to open your mic, please, before you do that, raise your hands virtually, and I'll put the order. I'm going to act as a moderator. That is from me, and without anything else to say, welcome all. We will have today Professor Bruce Ackerman. It's a pleasure. Sterling Professor of Law and Political Science, my 2 guilty pleasures, I have to say, from University of Yale, and the talk that promises to be a bit controversial, the Johnsonian Revolution, the Prime Minister's domination over the civil service, the judiciary, and the parliament, and its democratic dangers. Thank you very much, Professor. Obrigado, gracias, and well, the floor is yours.
Well, thank you very much. 1 second. And let me begin by saying, I'm sorry, I should have taken a drink beforehand.
Don't worry, I have my bottle here.
Let me begin by saying, please feel free to email me afterwards. My address is bruce.ackerman@yale.edu, very straightforward. It might take me a few days to answer, but I will try. Good. So Lord Hailsham said it first. In 1976, he was Chancellor, Lord Chancellor. He warned that, and I quote, Britain is moving in the direction of an elected dictatorship. As he explained, and I'll quote him again, a narrow majority in Parliament believe that the prerogatives and rights conferred by an electoral victory, a single electoral victory, authorize it to impose irreversible changes for which the majority of the electorate never consciously voted. I'll be arguing that the Brexit crisis has redeemed Hailsham's grim prophecy. The referendum initiated by David Cameron has not only destroyed the fundamental principles of parliamentary sovereignty expressed by the Parliament Act of 1911, but Boris Johnson has already established a system of elected dictatorship that will endure long after his reign as prime minister comes to an end, unless something very substantial is done about it. And that will be my question at the end. Well, what do you think can be done about this? If I'm right. If I'm wrong, well, no, I've been wrong before. Cameron, however, must share responsibility for the Johnsonian tragedy, as I will call it, with Tony Blair, whose Constitutional Reform Act of 2005 contained many otherwise admirable features, but also contained a clause of decisive significance for my argument. During the 20th century, Lord Chancellors like Lord Hailsham played three roles simultaneously. And by Blair's time, the Lord Chancellor was clearly overburdened by his responsibilities as both the head of the Judicial Committee of the House of Lords, which was, of course, the highest court, and as the head of the Privy Council, which had a role shifting and transforming so far as the Commonwealth is concerned. And so it made a perfectly good sense for the Reform Act to transfer these jobs to elsewhere, to other institutions, create other institutions. However, and here was the big mistake, there was a clause that eliminated the Lord Chancellor's position as a senior member of the cabinet who sat at all cabinet meetings, was not appointed by the prime minister, but was rather the highest judicial officer. We don't have to get into details about how his identity is determined, and that's familiar enough. My thesis is that it was a big mistake to eliminate the Lord Chancellor's position, the very position that Hailsham used as a basis for his effort to warn the country originally in 1976. To see why, I'd like you to distinguish between two ways in which the judiciary can constrain the abuse of power. One I will call preventive, and the other one I will call corrective. And to introduce the preventive, let's forget about Great Britain for a moment and look at France, Germany. When a law, and once again, of course, I'm simplifying, when a law is enacted by the French Parliament and affirmed in the appropriate manner by the President, before it goes into effect, it can go to, on an expedited basis, to the Conseil Constitutionnel, which determines whether the law is constitutional. This and prevents the politically elected officials to impose the president or the prime minister to engage in abuses of constitutional authority. the same. I begin with France because, of course, the French precedent established in the Fifth Republic has been of profound significance in Eastern Europe, and also the deeper French tradition profoundly significant in Spain and Latin America. But of course, in Germany, the same thing is true. The First Senate, once again, can, in an expedited way, determine whether a law that seems constitutional and valid to the prime minister and etc., the politically responsible, democratically elected politicians, leaders, can go into effect. The same thing was true 25 years ago in the United States. But now we can turn to the case of Great Britain. This is also the case in the United Kingdom. Consider, for example, I mean, just as one very striking example, it seems to me, the fundamental constitutional issue raised when Anthony Eden resigned his prime ministership in 1957 in the aftermath of the Suez crisis, with ill health being given as the reason. There was a fundamental constitutional issue. Who should succeed him? And there were two candidates, Grab Butler and Anthony Eden. Who decided this? Answer: the Lord Chancellor, Lord Kilmuir. K-I-L-M-U-I-R. I'm always weak on the British pronunciations, but he decided it. If he hadn't decided it, there would have been a tremendous political struggle. At a very vulnerable moment, I should emphasize, for the United Kingdom because of the Suez crisis. He resolved it, just as the Conseil Constitutionnel would resolve it. Of course, the issues are different. Constitutional issues are different, but that's, because the constitutional system of parliamentary government in Britain is different from the presidential system in France, et cetera, and so forth. But that's just from this comparative point of view, a detail. Although it is generally understood that the conventional wisdom is, of course, that the US and Germany and France and Spain and Latin America has judicial review, meaning that the high judiciary checks the politically responsible officials, and Britain doesn't. This is a fundamental mistake that was generated by the fact that the British system was even more effective. But it was confidential, you see. And it was taken for granted in the normal kind of Bagehot way of the effective as opposed to the symbolic, the Constitution, the symbolic the Constitution. Who is the Lord Chancellor anyway? I mean, he was around in the 14th century. A little bit different, actually, in the 14th century than in the 20th. No, yes, of course. Well, it's this is the way we adapt to things. But in fact, he was a tremendous authoritative source of constitutional restraint preventively. And my thesis is that when Tony Blair, and Tony Blair was a little bit on the ropes in 2005 as a consequence of his catastrophic decision to join George Bush in this foolish struggle that has led to so much tragedy. But Tony Blair had a lot of things on his mind, and a smart fellow, and the people who wrote the statute up, and Blair was on top of it. It wasn't that he was leaving this to someone else. This is a culmination of many of his admirable reforms. He didn't think about this, nor did anyone else, obviously. And the Lord Chancellor was abolished. And so symbolically, for example, who is the present Lord Chancellor? Robert Buckland, who is not even a senior member of the cabinet. He doesn't have a right to show up at every cabinet meeting. He is a Minister of Justice. Why is he there? Why is he the Minister of Justice? Not because, he is a perfectly competent barrister in Wales. He's elected in a very quite striking way. He's the first Conservative to be elected to his Welsh constituency in 2010, and is sitting there as a member of Parliament, not as the representative of the professional, serious judiciary. Let's consider a thought experiment or two. Let's imagine that rather than having Mr. Buckland as Lord Chancellor, we would have still had a Lord Chancellor. But this little clause in this very elaborate Reform Act had been omitted. I actually haven't followed it. It would be wonderful if someone actually knew the actual legislative history of this clause, because I don't. There are a lot of things I don't know. This is one of them. And suppose that he had remained as a check on Patricia May and her cabinet after the narrow defeat of the referendum, which David Cameron had every reason to believe he was going to win. That's why he did it. He did it because he had a problem maintaining party unity. Simple as that. There were some people against Brexit, including, of course, Patricia May, and some for. And rather than divide the party and open himself up to a defeat at the next election by a coalition of liberals and social democrats, he decided to kick it upstairs and get a referendum, looking back, of course, to the history of the first referendum, which was also done for the same very narrow strategic reasons, without thinking big about the constitutional principles involved here. And consider then, of course, what happens next. Lady Hale intervenes in Miller 1. Right. She would never have been obliged to intervene if there had been a chancellor. The chancellor would have vetoed the truly preposterous notion that the sovereign prerogative, this is after all Miller 1, enabled the prime minister to declare that the referendum is valid without parliamentary consent. This is an assault on the foundational principle of parliamentary sovereignty, especially when we look at the statute authorizing the referendum. The statute enacted by Parliament expressly stated that the referendum was advisory to Parliament. Expressly said it was advisory. Then suddenly we have a vote. What is the vote? The vote depends on how you count the vote, but under any way of counting the vote, less than 50% of the voters voted to leave. 49 to 49, 48, it's that not the kind of numbers with the Northern Ireland voting in significant part to hell with you. So not even a majority of the voters in this advisory referendum voted to leave. Now, I'm not talking about the merits here. I'm talking about I'm talking about the constitutional foundations here. It is the principle, foundational principle of this Parliament Act of 1911, which, after all, you see, confronts the unelected status of the House of Lords, which is resisting taxation of themselves. If you go back to 1909, 10, and 11. We have a typical British way of resolving through, muddling through, but effectively stripping the House of Lords of its veto. And establishing that what parliamentary sovereignty is ruled by the House of Commons. And we have a two-party first past the post system, which is struggling occasionally with changing party identities and things of this kind. So what we have here is to ask the question whether Patricia May, who, mind you, the day before had been opposed to Brexit, can say that this vote trumps the will of Parliament by invoking the sovereign prerogative on behalf of a referendum. To ask the question is to answer it. No sensible Lord Chancellor would allow this to occur. They would veto it. Period. So we should look at Miller 1 as an effort, and after all, it's unprecedented. That's what we say. Oh, Miller 1, unprecedented. It's unprecedented because it would never have happened before 2005. And after all, what we're talking about is, you know, a few years afterwards. We should also view the efforts by the Speaker Berkow. Is it Berkow or Berko? I'm not sure. Once again, unprecedented. It wouldn't have happened. It wouldn't have happened if there had been a chancellor. So enough of the thought experiment, but we could develop it at great length, and I would very much. I mean, I'm viewing this, you see, as a preparation for a rather elaborate discussion of these issues in volume 2 of my new series, alas, on comparative constitutionalism, where we'll compare this with a similar process that has gone on in the United States, which also involves the destruction of the preventive function of the Office of Legal Counsel, which was a necessary condition for Trump. But the Europeans still have it. Both a parliamentary form, as in Germany, Spain, whatever you want to say about what the Spanish are doing, the Spanish court is doing vis-a-vis Barcelona right now. They're doing something preventively. Whether it's wise or not, is a different issue. Sorry. Similarly in Germany. So this is a very central element in a distinctive crisis of the Anglosphere, which is worthy of reflection. But for present purposes, I'm just focusing in on the British case because that's what you know about. And in the real world, what does Patricia May's selection as Prime Minister represent? It is, from my point of view, classic example of the British muddling through. Let the French and the Germans and the Americans talk about all these abstract constitutional principles. We adapt by muddling through, by having a pragmatic solution. The reason why May is selected, even though the day before yesterday she was opposing Brexit, is so that some person like Boris Johnson would not take over the party. That's the reason, and it's and that is, from the point of view of the British thing, perfectly understandable from an outsider's perspective, who is not trying to say there is one constitutional path that everybody has to follow. The whole point of my books series is to say, no, there aren't. There are several different paths. So what we have here is a May trying to say, aha, yes, I'm going to try to muddle my way through on the basis of the will of the people as expressed by a referendum, which got 49% of the vote. Oh, don't give me that. Lady Hale, really. We are going to make a good deal. The next stage of the tragedy, of course, is that she fails. I mean, she was preeminently a sensible person and trying to, but it was like too difficult. And I understand that. She fails. Then we have the implication, which I'm not going to, we have another, compromise, prudential muddling through the statute of 2011, which made it an election difficult. But we then finally have this snap election for the new parliament. And once again, the British system fails. Here was a crucial test of popular sovereignty. Generally speaking, what was the crucial question? Should we rethink a Brexit or not? That was the obvious and big question. And thanks to Jeremy Corbyn, it was not asked. Instead, we had one side, Boris Johnson, saying out. And the other side saying, I'm never good. Let's keep the Labour vote, and so forth. Fundamental failure of the parliamentary system, as I understand it. What is the parliamentary system? Both sides say what their program is. Not in any elaborate way, but in terms of, should we have socialized medicine or not? Right? Would if Churchill had won over Attlee, the answer would have been not. We would have been fighting in India. On behalf of Lord Mountbatten, you wouldn't have been celebrating the National Health Service. But Churchill lost. That was what happened. And Attlee won. Very self-consciously saying, listen, let's reconstruct Britain first. Perfectly understandable. It was, reasonable people could have differed. But here, in a similar crucial turning point, the British people were not asked to make this choice. And then when Corbyn leaves, we have a leader up of the opposition who goes, while Johnson says, I have this mandate on the basis of the popular sovereignty expressed initially by the 49% Brexit vote, which is not parliamentary. Okay, now, then we have this remarkable fact that as a result of Brexit, an enormous chunk of British law, which presupposes the existence of the European Union and its membership in it, disintegrates. And we have this remarkable a process which we're suddenly talking about Henry VIII all the time, without actually appreciating. I appreciate the historical irony, to put it mildly, that this is much more than Henry VIII would have ever imagined that he could do. Half of the law of Britain is ran through without any parliamentary consideration. on Henry VIII clauses. So because there's this, there's this big gap in the law. You need the law immediately. I'm not talking about the Brexit part of negotiation, mind you. I'm talking about internal. So that is remarkable. Moreover, of course, going back to Brexit, we have this Johnson's assertion that his victory in the election, his landslide victory, which, as was warned by Lord Hailsham, remember, a narrow majority in Parliament believe that the prerogatives and rights conferred by an electoral victory authorize it to impose irreversible changes for which the majority of the electorate never consciously voted, permits him to prorogue Parliament, generating the Miller II, which wouldn't have happened if there had been a Lord Chancellor. And moreover, with great respect, I am a great admirer of Lady Hale, and one of the things that Yale does every year is have a global constitutional seminar where justices from around the world actually typically come to New Haven, and we spend 3 great days of confidential conversation on big issues where people, compare things. It really is without that, I'm sure I would never have embarked on, or it's one of the fundamental resources over the last 25 years that I've had in my own work. But Lady Hale's Miller II, however much she is protecting the principle of parliamentary sovereignty, was a failure. The number of hours that Parliament actually met during the 5 weeks, I don't know how many, but there was no serious debate and consideration of the Brexit terms. Couldn't be 5 weeks anyway. And of course, the COVID thing made it much harder, et cetera. I mean, there are a lot of things, but it didn't actually vindicate the real principle of parliamentary sovereignty. Despite this, Johnson is now engaging in the politicization of the civil service in a way that will really effectively make serious efforts at either parliamentary or judicial checks on future elected dictators. I'm not talking about Johnson only. You're establishing precedents for the future here. And to conclude by this, just consider, despite Dominic Cummings' departure, we have his triumph in the real world. The permanent secretary, the cabinet secretary, has shifted from Mark Sedwill, a seasoned professional, to Simon Case, who is 42 years of age. Unthinkable. Unthinkable. Permanent cabinet secretary is at, at the peak of his civil service career and has been in complicated ways selected precisely because he has gained the admiration of his peers for the professional discharge of whatever the government's program is. And when the labor moves into conservative and vice versa, the Parliament and Cabinet can be confident that there will be a sustained professional effort to implement the program regardless of the political beliefs of Sedwell. Sedwell, I'm sorry. Case is picked by Johnson for the very purpose of picking someone who Johnson believes will really do everything possible to fulfill his mandate. A mandate, as I said, which is not one that was actually generated in the classic Bagehot way. He shows every sign of deferring to someone named Dan Rosenfield, who also, by chance, is 42, and who carries this title, Downing Street Chief of Staff. And the key decisions are made in the war room rather than Parliament. Simultaneously, we have the Johnsonian assault on judicial checks of the corrective form. And this is exemplified by the government's reply to the Independent Review Commission on Administrative Law, a report signed by none other than Richard Buckland in his nominal capacity as Lord Chancellor and Minister of Justice. And what does that do? It says, we shall enact ouster clauses. We can oust the judiciary from any jurisdiction whatsoever over the rationality and rational relationship of bureaucratic action to the statute. Ironically, citing Lady Hale, quote unquote, courts are the servants of Parliament, which means, says Buckland, that if we pass a statute which says you shall not even consider whether there's any relationship whatsoever between the statutes and your actions, you're ousted. And don't tell us that the judiciary has this intrinsic authority to be, modest and cautious, modest, but nonetheless, using common sense criteria, is this action related to the statute? No, we can say no. Similarly, we can have quashing orders. That is to say, even if we haven't engaged in ouster, and so the court is using its normal, principle that there should be some rational relationship between the statute and the challenged action. We can then retroactively enact a statute or a provision, maybe not a statute, we should enact a statute which would give a ministry, perhaps, or something that was not clear from the government reply, to say, we hereby quash the order issued by the judge without appeal. So, in conclusion, we are already the parliamentary system established, that we have budget, the ceremonial and the effective constitution. On the level of ceremony, parliamentary sovereignty has been shattered. On the level of the effective constitution, it doesn't exist. Now, what should be done? Well, that's the question. At one point, Julian Legrand and I published in various places the proposal that Britain needed a new constitutional convention, that you needed to have really a written constitution. I still believe that would be a good idea, but it's not going to happen. That's the fact of the matter. And I am not a philosopher king talking about what's ideal. The whole point of constitutionalism is to marry theory, principles, and practice in ways that stand up within a particular political culture. Given the fact that the British Constitution of parliamentary sovereignty has already been smashed, the question is, what can be done in, let's forget about Boris Johnson, in the next 10 years? After Boris Johnson leaves and someone else gets in there. Of course, it depends on who that someone else is. But hopefully it won't be another Johnson, Trump demagogue. Hopefully it will be somebody who is a statesman. Whether it be of the left, right, center, I don't have the slightest idea. It seems to me that it's your task, not mine, because I'm an outsider trying to look at insider, but I actually know something about the inside. How to correct the situation, short of a constitutional convention. I don't know. And that's the question I leave for you, as well as many others raised by this talk, I'm sure. Thank you very much.
Thank you very much, Professor Bruce Ackerman. And let me stop the recording and we'll open for the discussion. Just a second.